Welcome to today's episode of the SADF Podcast, where we deep dive into the pressing issues of our time. I'm your host, Rayhan Rashid, and I'm thrilled to have you join us for what promises to be a truly interesting conversation today. Our topic today is about the recent recommendations for constitutional reform in Bangladesh, proposed by a committee appointed by the interim government. These committee's recommendations have already raised a lot of eyebrows, especially given the controversies surrounding the legitimacy of the interim regime itself. So what the reforms mean? It meant from changing the name of the country to proposing fundamental shifts in the constitution's core values. These recommendations are raising serious concerns. There are questions about authority, questions about intent, and also about consequences. So, to unpack these complex and critical issues, we are honored to have with us Barrister Tania Amir. Barrister Amir is a senior advocate and a distinguished expert in constitutional law. So, let's get started. Welcome, Tania Amir, and thank you very much for joining us. It is so great to have you with us today.
Thank you, Rayhan. Pleasure to be with you.
My first question, I know the answer may be pretty obvious, but I still need to hear from you anyway. Could you briefly explain why constitutional reform is such an important issue, especially in current Bangladesh?
First of all, constitutional reform or amendment, it can only be done by an elected parliament with two-thirds majority. So this so-called constitutional reform or amendment is non-est in the eye of law. It doesn't exist. Whereas politically, we do see the radicals, the jihadists, they do have a problem with the secular democracy, which is what Bangladesh is as per its constitution. Successive governments, to what extent could implement that. But de jure, Bangladesh was born as a secular democracy. So majority Muslim people in Bangladesh have gifted ourselves a constitution based on secular democracy. Most majority Muslims living around the world, this hasn't happened before. So most Muslim rulers are ruling through divine prerogative, a special family, or through some sort of a military adventurism. But in terms of the people having sovereignty, gifted themselves a nation, an autochthonous constitution, and the sovereignty of the republic belongs to the people, this just doesn't exist anywhere else. So we are a nightmare for Muslim rulers around the world, and we are a ray of hope for Muslim people around the world. So those who are ruling would want to therefore undo this so-called, they deem Bangladesh as an experiment, and this experiment will have to be undone. So the whole purpose and ethos is to take away the secular character of Bangladesh, which is why this attempt, an aborted attempt to amend the constitution or give recommendations for amending the constitution, which the present government has no mandate to do. So this committee itself is quorum non-juris.
I will come to that issue of mandate and authority. My next question is, given the perception that the interim government itself lacks a constitutional mandate and legitimacy, what legal standing does this reform committee have to propose such fundamental changes?
There are two questions embedded in this one, whether this government has any legitimacy or not.
Itself.
Yes.
Yes.
And the second is, if it doesn't, then how does this committee get its legitimacy? And the converse is that if it does have legitimacy, then does this committee have legitimacy or not? So let me take one by one. This government claims that it came into power by virtue of the fact that there was a vacuum in the government. So the HPM had left Bangladesh, and then the parliament was dissolved, and the sequence of that, who can dissolve parliament, these are all issues that we need to look into. But then what happened is that allegedly the president of the republic sought an opinion from the Supreme Court, the appellate division of Bangladesh, by virtue of Article 106 of the Constitution.
That's for referral, right?
That is a referral, that what happens when there's such a vacuum. And allegedly, the opinion was that if there is such a vacuum, then there could be an interim government. And this is the pillar and strength which the government alleges is their source of power and legitimacy. All right? So now no one has seen this opinion. I have tried personally through my law clerk and various friends in the media, journalists from the good office of the Registrar of the Supreme Court, from the concerned ministries, to get a copy of that. Now, why is this such a secret?
Is it not supposed to be a public document?
Absolutely. It needs to be a public document. The shroud of secrecy needs to be totally removed, and this should be made public. No one knows what exactly it is, whether at all the President made a reference or this reference went through the office of the Secretary of the Law Ministry, how this happened, and what was this reference or the opinion sought was predicated upon. If it is predicated upon the alleged fact that the Prime Minister resigned, that itself calls into question because there is no resignation letter to be found
That
anywhere.
is the mysterious bit, and there are three elements to it. The resignation letter itself, that was never shown to the media and that was never acknowledged. So we do not know if that exists at all. But by resignation letter, I mean the letter of the former Prime Minister. And then this issue of reference from the Chief Justice, from the Supreme Court, on under 106. As you say, that hasn't been made public. The third thing is the whole Supreme Court was surrounded and removed by a mob. They were made to resign. So the whole thing is quite mysterious and
The
quite
security
curious,
of
actually.
tenure of judges, which is a cardinal principle of any civilized society
Exactly.
and a democracy, that is under threat because this so-called mob, it seems to be extension of the current government's, a sort of a kind of a vigilante because
Vigilante, yes.
they keep going to offices and they had entered the chamber of
The judges.
honorable judges and intimidated them, threatened them with threats of violence that they need to resign. And we've all seen the videos, the mayhem in the Supreme Court premises that I would say they're unemployed youths or unemployed
This is so
litigants.
unprecedented. The Supreme Court itself, the judges themselves, all of them, they were under attack. And this all took place when there was a sworn-in new government, the government of Dr. Yunus, right?
Right, so we take step by step because your first question was the swearing in of the government. So
That took place on the 8th of
yes,
August.
so this alleged reference from the Supreme Court occurred before that, but no one has seen that. So then the government took oath by swearing allegiance upon the Constitution.
Constitution.
Right? So now, whichever way we look at it, this government is therefore is arising out of the Constitution itself, as per their own assertion. The government asserts that they are a product of Article 106 of the Constitution. So there is no question, therefore, that the government is not denying the Constitution. Anyway, it can't, right?
Yes, it can't.
So that is the first thing. And there are questions. Then the next question is a government which is a creature of the Constitution and the Constitution as a solemn expression of the will of the people is the supreme law of the Republic. So one of the cardinal feature of this Constitution is that sovereignty, all powers of the Republic belongs to the people, which is unlike the British Constitution whereby the sovereignty belongs to Parliament. So we are rather similar to written constitutions perhaps in USA and our Republic of Ireland perhaps, where we deconstructed sovereignty. So, in the old days, sovereignty belonged to the monarch, and there was a quarrel between the monarch and Parliament saying that, if the monarch had all the divine power, then why does the monarch need to tax the people? If the monarch needs to tax the people, then there have to be representation and no representation and no tax. So we all know that history, and in that quarrel, Parliament won. So in countries like Bangladesh, where we have written constitution, we deconstructed sovereignty further down. And here, even parliament is not sovereign. Sovereignty belongs to the people. And as a solemn expression of the will of the people is the constitution. And through the constitution, the written constitution, the people have actually said that how this sovereign power is to be exercised through the three organs of the republic. So the executive, the judiciary, and the parliament, the house of the nation, how this sovereign power is to be exercised and check and balance is to be maintained. So that is codified and expressed through the constitution as a solemn expression of the will of the people, and the will of the people is supreme. That is the premise. So now the government, the executive organ of the republic, is a creature of the constitution and subordinate to the constitution. So the government cannot do anything that contradicts the constitution. And the constitution itself, as a supreme will of the people, how the constitution is to be amendment in a codified constitution, that has also been uttered by the people.
That is crucial.
Yes, and that is by way of 2/3 majority in an elected parliament. The power
It
to
can
amend
only be done by the elected representatives.
The power to amend the constitution has not been given to any government, right? So no executive organ of the republic has any authority to amend the constitution. So this is number one. The attempt by any government to do so is ultra vires. And then the power that this government doesn't have, how is it purporting to exercise that? So it created a commission, and the commission is supposed to give recommendation for the government to do what? Nothing. So how is the taxpayers' money being wasted to create a commission, and the commission to give a recommendation with which the government can do nothing? A big fat zero. So the office bearers of this Constitutional Reform Committee is non-est. So a wonderful writ petition, a public interest litigation can be filed challenging under what authority this Constitutional Committee has acted or continues to act, or assert their authorship to this report.
We'll actually come to the legal challenges. I would like to hear more from you on that.
This would be a quo warranto case that they have no authority.
Yes.
A quo warranto case, yes, that they have no authority whatsoever to claim any authorship to this proposed amendments.
So basically, it is the quo warranto means for our viewers, basically challenging the authority of an office, right?
The office bearer. And even for the purpose of constitutional reform, this quo warranto can also be filed against the chief advisor along with his cohort of other advisors, because they almost asserting themselves that this is something that they can do, which is a fraud upon the constitution and therefore fraud upon the people. They have never said that we have authority to do this. And if they have no authority, then why on earth have they then created, by way of a subordinate office order, and this is very important, Rayhan, that the executive order is a subordinate office order trying to amend the highest law
of the land.
So the hierarchy of law, if you like, by way of a subordinate office order, one cannot purport to change or amend the highest law of the republic. So in the hierarchy of legal structure, it totally falls apart. It's non-est. Secondly, amendment as per the solemn expression of the will of the people, and the will of the people is supreme. Sovereignty belongs to the people. The people have said already that this written constitution, which is an embodiment of the supreme will of the people, they have already asserted, the people have already said that this is not a rigid constitution.
Yes.
This can be amended. And the people have said how this can be done. And this is 2/3 majority of an elected parliament. Present government has no authority to bind the future parliament. in any manner whatsoever.
That's
The
a very
so-called
important principle, like binding the hand of future parliaments. But for argument's sake, let me just ask you this. What if someone argues that it is just a mere academic exercise, that the committee, they just gave a few recommendations and those are not binding, and any person can dive into the Constitution and have an opinion which we do not have to agree with? So what's wrong with that view, or are we missing something here?
Right, Rayhan, the government hasn't said that. This is why I said it is fraud upon the constitution, fraud upon the statute, because the government is pretending that it has the authority to do this.
Exactly.
Right? So this pretension is totally unauthorized. This pretension is fraud. If the government is saying, well, we are just going to do an academic exercise by wasting
They didn't
taxpayer
say that,
money,
just for the
just
hell of
for
it.
fun, and we're not going to do anything about it. Now, that would again land the government in trouble. You see, because the government is delaying election on the lame excuse of implementing these reforms.
Reforms,
So the
exactly.
government has created number of reform committees, including the Constitutional Reform Committee, right? And the government is asserting politically that it will bring about the reforms recommended by the various reform committees. Only then, I
Then,
repeat, they will hold election. Now, this is the fraud upon the people, and this is why I'm saying it most emphatically. This recommendation is non-est. It cannot be implemented. What does that mean? The government, therefore, in perpetuity will not hold election. Professor Yunus indicated that the elections will be held end of 2025. His press secretary said, well, end of 2025, maybe mid 2026. Right? So we are seeing the goalpost is being shifted. Now entered the scene the meticulous planner, according to Government Yunus, who has been made one of the advisor, and many people claim he's member of the Hizb Tahrir, which is a banned organization in Bangladesh and world over. And Hizb Tahrir as a political entity or a dogmatic entity, its roots are not in Bangladesh. They're a global multinational organization. They have branch in Bangladesh. So its birth is not from the soil of Bangladesh. Now, what has he said? He said elections are going to be held subject to these reforms.
implementation of the reforms.
Subject to the implementation of these reforms. So this is the fraud upon the people. And people, we have to wake up and realize what's going on. So should the government say we have no mandate to do this reform, then by corollary, the next logical step is that therefore elections cannot be subject to this reform because we have no mandate to do this reform.
So basically, we are going in circles here.
We're not going in circles. It's like in perpetuity putting off election. How are we going in circle? If you see their logic, Mahfouz Alam has been made an advisor. Incidentally, I don't think he has ever held any job. He has no experience of running any office. He's never been even an entrepreneur. They claim to be students, but I have not seen any student ID. So I don't know what is the credential or what they do. So apart from what's come in the media that he's changed his name, similar names, and he is a member of Hizb Tahrir and so on and so forth. Beyond that, I don't know anything of his credentials. No CV has been given because, most office bearers, government office bearers doing an elected regime, they have to give their CV and tax return. So no one has
No
seen
one
their
has.
tax return. So have they ever even had any known source of income? If not, how have they run their lives? So are they taking donations or are they taking income which is shrouded in secrecy from organizations that are banned? We don't know any of this. So certainly their living and their expenses, how are their expenses being met before they took this office? This is crucial. People demand to know that. We need to know that because the office bearers of any government office, elected ones, even unelected ones, the norm is they have to disclose their tax file. If they've never had their tax files, then it begs the question, what stakeholding do they have in the functioning of the republic? And now suddenly they're saying that these reforms And the constitutional reform is not permissible, it's not possible, it's a non-est. That no election will be held unless these reforms are implemented. So what are they
Yeah.
talking about?
My next question it is about the proposals themselves, as the very legitimacy of these reform proposals is in question, and particularly the reform committee is in question, their legitimacy. I'm actually in two minds whether we should at all discuss the content of the committee's proposals or whatever they are. Do you share this dilemma?
Well, for me, there's no dilemma at all. Something that is non-est, it doesn't exist in the eye of law. I will not dignify it by going into the substantive
Into
contents
the
of
details of
what
it.
it is. Yeah.
I see the point.
But even before this committee gave the report, I could have told you what they will go after. As we said at the very beginning, the committee will go after secularism, right? As I've indicated, because we are the first majority Muslim people who have given ourselves a constitution based on secular democracy. So the jihadists and the Islamists are most uncomfortable
With this principle.
Yes, with the principle of secularism, because they want to rule through divine decree, through divine power. So what Christianity has gone through in the Middle Ages, the Islamists are purporting to go through this now. Whereas for most of us, most Muslims in Bangladesh, the Islam we understand is an Islam of peace, and we have never known this political Islam. So before Maududi, who was the founder of Jamaat Islam, the idea of political Islam did not exist at all. So these so-called who are asserting this political Islam are also misdirected themselves, both in the path of faith and misdirected themselves in the question of fact and law, and purposefully they're doing that. So
There is
they're
no
telling,
this
yeah,
there
they're
is
telling
no,
the rest of us Muslims, well, you don't know what the religion is. We are somehow authorized by Allah to rule upon the rest of you, the lesser Muslims, and we will rule by divine laws, and we only know what these laws are. So my question to them has always been, where, when, how did Allah give you this power of attorney to implement Allah's laws? And only you know what they are, and the rest of us don't? Where have you come from? Who are you? We don't acknowledge you. The rest of us who are also assert ourselves with our Islamic tradition, the long-grain tradition of peace, of toleration, of inclusiveness, which is what Islam that we understand. We don't need to learn your Islam of hate
so
and Islam
basically
that divides.
there is no surprise that secularism has been removed from the constitution. They suggest a
Yes,
removal
because
of it.
I think it's appropriate to invoke the Medina Charter. So when Prophet Muhammad, may peace be upon him, was about to sign the pact along with the leaders of the other non-Muslim communities and atheist communities and Zoroastrians, the Jews and the Christians, Hazrat Ali, after the name of our beloved Prophet, wrote that Prophet of Allah. Now, Prophet Muhammad took the pen and crossed this out. He said that I'm not signing this as a prophet of Allah, as a religious leader. We are signing this as community leaders, and all the communities are here co-equal. So that had no connotation as to how Medina is to be ruled and governed, which is through consensus of all the different communities that were peacefully and in harmony cohabiting in Medina. Now, this is the essence of Islam. And those who assert otherwise are actually going against the tenets of Islam. That Islam is inherently secular.
That's a very interesting point. Let's now talk about the people involved in the reform committee. Do you think we should be looking into the individual background and expertise of the people involved in this reform committee? I ask this, there is a reason. Because do you think the absence of constitutional experts in the committee influenced the nature and quality of its recommendations?
Absolutely. I think generally, I would not go into and look into the individuals of a committee unless there was conflict of interest. So in this case, there's legitimate reason and ground to look into the constitution of the members,
Some of the members.
of this committee. And the second reason I would look into it and question the status of the members if they had expertise in the subject matter or not. So these are the two reasons.
That should have been the first criteria, right?
Yes, this is a conflict of interest and whether they have expertise. Now, on both ground, there are issues here. So in this so-called Constitutional Reform Committee, I don't see a single constitutional expert there. People who have practiced constitutional law, particularly of that of Bangladesh, and they have expertise in the subject matter. There is not a single constitutional expert there. In fact, some of them are not even lawyers, constitutional lawyers. And then some of them are teachers at universities and others are sort of young practicing lawyers with maybe, So none of them are constitutional experts. So let's put it that way, In a constitutional reform committee, you must have someone who is a constitutional expert who is heading that. And I believe that the original jurist who was asked to head this committee, he gave an interview and he said that there's no need to change.
You are referring to Dr. Shadin Malik.
Yes, so he said that there's no need to, change the constitution.
Yeah, he saw no need.
Such. Yes.
Was it because he was removed, or how do you put it?
Well, it's significant because as soon as he gave this interview, he was just removed, he was dropped. So this is possibly the desire of the government. His comments were contrary to the desire of the government because, as I said, this is a fraud upon the people because if there's not to be a major reform...
So basically the government didn't want an independent expert or independent voice. They wanted someone...
No, I'm saying something else, Rayhan. If there's no need for a major reform in the constitution, then this stance by the government that the election is subject to this reform falls apart, right? So constitutional reform this government can never do. So therefore, if the election is subject to reform, does it mean in perpetuity the government has a desire?
Yeah, that is why actually I'm trying to get at Tania Amir, because basically the government wanted someone in the committee to head the committee who will follow their line or follow their agenda. So that was the kind of the thing, and probably that was the reason Dr. Shadin Malik was dropped from the committee, because his views were not in line with the regimes, I think.
Absolutely. I agree with that. In addition, I would say that since Shadin Malik said that no major reforms were necessary, so the government is playing this game that election is subject to reform, and BNP is very upset about that. So if no major reform is necessary, then how does government justify itself in continuing its office in perpetuity and staying in power longer than is necessary? Yeah. So that's another reason. Yeah, that's another reason. So now in terms of the first one, that there are no constitutional experts, hence I think we should look into the individual names that are there. And the second one is the person who is heading the Constitutional Reform Committee. Now, I understand he's a member of the Atlantic Council.
You are referring to Dr. Ali Riaz, I think.
Correct. So he is an academic in USA. So now he is, I believe, is a US citizen. I don't know if he's a dual citizen and to what extent US allows dual citizenship. So once you become a US citizen, could one still continue to give allegiance to any other country?
Isn't that contrary to his oath of US citizenship?
I'm just coming to that because you see, with the Commonwealth, it's different. When you become a citizen of a Commonwealth nation, you could become a citizen of different countries as well as other Commonwealth countries, and there is no conflict of interest to having allegiance with more than one country within the Commonwealth, and it's the historical past. So Commonwealth countries is a different issue, and I flag that very seriously. But with US, once you become a citizen of US, you have to give allegiance to only US and no other country.
Exactly.
So that itself, to what degree it provides a conflict of interest of nationals of Bangladeshi origin who have taken the US oath by virtue of becoming a US citizen. They cannot have allegiance to any other country. They can only have allegiance to US. And so far as the US laws are concerned, to what degree they recognize their citizenship of other countries, that is also a question. So whereas within the Commonwealth recognizes each other's dual nationality. To what degree the US does that is something that one has to
I
look
understand
into.
your point.
Yeah.
So,
The second
so
point is, so that's number one. So once you've given allegiance to the US flag, whether you can also have allegiance to the Bangladesh flag, right? That's number one. Number two, he is a member of the Atlantic Council. Now, Atlantic Council was set up to promote US leadership and influence globally. It gives all sorts of support to NATO. So once the North Atlantic Alliance, NATO, was formed, the Atlantic Council was set up, was created to support NATO, and he continues to be a fellow there. So again, there's an allegiance towards NATO and the Atlantic Council, whose allegiance is to create US dominance globally.
globally.
US leadership and dominance globally. That poses a direct conflict of interest when you're tampering with the constitution of Bangladesh.
So
And
that
that
begs the
makes him
question. That begs,
totally disqualified. So the quo warranto case that I'm talking about, it's that the government has no authority to appoint this committee, because this government or not this committee can recommend anything by way of a subordinate office order to change the constitution. That can only be done by two-third majority of elected members of parliament. No government has been given this power, only parliament has been entrusted with this authority. Secondly, this committee headed by a person who has a direct conflict of interest with that of Bangladesh, of
because of
touching the
being a
Bangladesh
US citizen.
constitution, because his allegiance is to USA, and his continued membership with the Atlantic Council, which promotes domination of US leadership and influence globally, that is absolutely, totally in conflict with the sovereign will of the people of Bangladesh, and the constitution is an embodiment and a solemn expression of that will of the people in a written codified form.
So that
So
begs,
for a US citizen and someone who is a member of the Atlantic Council, which promotes US dominance across the world, is totally disqualified to head this committee. The exclusive jurisdiction is given through the Constitution itself to the elected representatives, which is a parliament, the legislative organ of the Republic on the one hand, and the executive organ of the Republic. So the executive organ cannot usurp the role of the parliament, the House of the Nation. So here we are seeing a usurpation of parliament.
power.
Yes, so the executive is usurping the power of parliament, which has to be crushed immediately. Executive cannot usurp the role of parliament, and the executive is in usurping this role through creation of this through their subordinate office order, and creating this constitutional reform committee, who are also thereby usurping the function of parliament and parliamentary committees. So this Constitution Reform Committee will be a committee created by Parliament to give recommendation to Parliament. So this committee can only be under the auspice and direction of parliamentary subcommittees.
Exactly.
Right? So they are pretending to be something, a parliamentary subcommittee, which they are not. They cannot be a creature of a executive organ which created them. They're a creature of a subordinate office order by an executive organ of the Republic, which they cannot be. This can only be a subcommittee created by the Parliament itself.
Of course. Uh, so that brings us to the why question. Let's talk about motives or motivations behind all these shenanigans. In your view, are these recommendations politically motivated in the sense that they're engineered towards a political agenda? And if so, what specific agenda might that be? What do you think?
As I
Because
said,
the reason they're so desperate or they're walking this line, there must be a reason from their point of view. And what could, by reason, I mean agenda, actually.
I think there are two. First is very obvious, we have already discussed. In fact, both we have discussed indirectly.
So please, if you can repeat it
Highlight
for
it
our
again.
viewers, yes.
First is not to have elections.
Okay.
Right? So to delay the election, not to have
So,
it.
first is that to delay it indefinitely.
Indefinitely, right? So this government, as I said, is an interim government, and we don't know their source of authority or power because we have never seen the opinion under Article 106 of the Constitution, which the government asserts that it has derived its authority from. And the government ought to have made it public. It is not a secret document. People do not have to invoke the Information Act in order to get that. It is in the interest of the government to show, well, here's the opinion, and based on this opinion, the first thing they should have done, right? So they're not doing it. So whenever this lack of transparency, it makes you wonder, and it's usually inevitably the case that there's some hanky-panky there. Otherwise, why shouldn't we get to see that? Because they're serving the people at the end of the day. That's number one. Number two is that the agenda, it seems, is to remain in power by virtue of this 106, an opinion of the Supreme Court, seems to be indefinitely. Why do I say that? Because the government has failed to give a definite date to hold election. And to hold election under the caretaker government, which was a feature of our constitution under 13th Amendment, which incidentally has been resurrected, and I'll just come to that, is 3 months. So if the caretaker government can hold election within 3 months, this government is already in power for over 6 months, right? And it hasn't taken any steps. Rather, it's giving lame excuse one after another, one reform committee after another, that unless these reforms are in place, are not going to give election.
What the two possible motivations or motives behind. I noticed I didn't want to discuss the content of the proposals, but I must mention this one. In the proposal, they actually suggested removal of Articles A of the Constitution, which is in regard to the crimes against the Constitution. So they want the provision removed. I wonder why that particular provision removed. And do you think there is fear of future sedition charges or?
In previous, I think, talks with you and others, I've already said that they are already committing treason and sedition. So they are challenging the proclamation of independence. They want these so-called hooligans, these unemployed hooligans, who claim themselves to be facilitators of the students' movement, and they assert themselves as students. And as I have already mentioned, I've not seen any student ID. They're not students at all, so we don't really know who they are. And one of them have clearly said that while this movement was going on, there were comrades were members of Shibir. And out of 157 so-called coordinator, 108 were Shibir activists, which also they purported to dupe the people. So there was a shenanigan. There was, if you like, lack of transparency when this movement was going on. They didn't say that they are members of Shibir, which is a banned organization in many countries around the world, according to various European think tanks. The point that I'm trying to make is that you're talking about the motives, and the motive is, it seems to be, that there was a third force who believe, who are like jihadis, and they believe, as I said, Parliament's ability to enact laws. They don't believe that. So this Constitutional Reform Committee is in line with that. So this power is given exclusively to Parliament. They don't want Parliament to be doing any one of this. So one motivation is to delay election. The second motivation, as I said, is to remove secularism. And while they have removed secularism, they have intensified the state religion. So the state, they have said the state must have a religion, which is an oxymoron, because the state is an artificial entity, cannot have a religion. The state
Yes.
cannot perform Hajj, the state cannot perform
Of course.
puja, the state cannot perform
So what is the other reason, the third
yeah.
one?
So if you like, let's just finish that. During the Pakistan time in 56 constitution, the people from East Bengal never wanted any state religion, which is why Pakistan never really had a constitution which was ratified by the people. So this constitution was purported to be imposed by these various committees created by the Governor General. And I just want to flag this again, that, founder of Pakistan, Mr. Jinnah, did you know that Mr. Jinnah was also the Governor General of the King at the time?
Yes.
So Mr. Jinnah actually held two flags when Pakistan, a dominion, an independent dominion. So there was a British Parliamentary Act, Indian Independence Act, by virtue of this, two independent dominions were created. One was India, one was Pakistan. India had its own government, and the Governor General representing the British Crown, Lord Mountbatten, played that role separate from the Indian government. And within 2 years, India had a constitution and it became a republic. Pakistan, that never happened. Pakistan did not have a separate Governor General who had allegiance to the Crown, the British Crown. And whether Pakistan was ever an independent state or nation, because Pakistan never really had a constitution approved by the people. So the Governor General would create all these committees, just as what is happening now, right? There was never any election till 1970, a free and fair election. So the analogy I'm drawing, the executive and sometimes the representative of a colonial superpower, and now we are seeing a representative of the North Atlantic Council, NATO, is heading this. So similarly, when these constitution committees were created, the 1956 constitution and so on, it was never done by parliament. There was never any parliament, and that is the analogy with Pakistan that I'm drawing.
No, I get
So
it.
it was top down, yes, and Pakistan continued to have a Governor General system, right, who were representatives of the British King. So homage to the Crown in the UK, right, continued. And Pakistan's 56 constitution, people from East Bengal, us, the
Paid for
Bengalis,
it.
we never acknowledged and approved a constitution which is going to be Islamic Republic. That was abrogated. So then the army played a role. So Pakistan was always governed through the barrel of a gun. Pakistan never had a constitution adopted by parliament until 1973, after the birth of Bangladesh. So the first election that Pakistan held, free and fair, was 1970, to give the people of Pakistan a constitution. And we, the elected representatives, which had overwhelming majority, out of 169 seats, the Awami League had 167 seats. We presented a secular constitution, a copy of which was given to the Pakistan authorities. Now, the unjust, treacherous war that was imposed upon the civilian people of Bangladesh, instead of handing over power to the elected representatives, one of the reasons was secularism. Pakistan could never, because they believed in Islam which is dogmatic, and certain elements in Pakistan, the radicals wanted to rule Pakistan based on this divine power, divine prerogative, and only they know what these divine laws are. So they want to impose God's laws. And in Bangladesh, our birth is based on secular democracy. The analogy that I'm drawing is that in Pakistan, one of the reasons that this unjust and treacherous war was imposed upon us, because we wanted to have a constitution on secular premises. And again, the same thing happened in the Proclamation of Independence. It said the will of the people is supreme. So the elected representatives got together, transformed themselves into a constituent assembly, and ratified the declaration given by Bangabandhu.
Yes.
And since the will of the people of supreme, Bangladesh emerged as a sovereign People's Republic of Bangladesh as a sovereign nation, placing our allegiance on the United Nations Charter and accepting all the rights and obligations and duties that devolve upon us as a member of the family of nations. Hence, if you like, this constitution, the people have therefore given themselves, because Pakistan made it impossible by pledging a war against us. So this is where the problem is. It is sort of trying to undo the premise upon which Bangladesh was born, take secularism out, and in order to have a state religion. And I am also upset with all the previous governments. They didn't have the courage to take the state religion out. Even with the previous government, in the preamble, which can never be changed, a preamble is part of the basic structure of the Constitution. Secularism, Article 12, we're talking about secularism, yet we're talking about state religion. You cannot have the two. And what the previous government did, that rather than making Islam the only state religion, they went on to give all the other religions the same status, which is really very, very confusing. First, you cannot have a religion, and how does a state have multiple religions at the same time? And the state can never have a religion. It's an oxymoron. It is not possible. A state is not an individual. So the separation of state and religion, when the constitution was abrogated, we had intervention by the army and extra constitutional regime. The attempt has been always to make the constitution an Islamic state, short of an Islamic republic. So the idea is to introduce state religion, introduce Bismillahir Rahmanir Rahim, starting the constitution. So this attempt has always been going on, whereas the people of Bangladesh are not confused. In the spiritual realm, most Bangladeshis believe that there is a higher power, there's a superior power. Most of them believe in Allah or Bhagavan or Jishu, Jesus Christ, of the various religious denomination. But on the temporal world, when there's governance, the most people, not most, 99.9% of the people believe that those who are going to govern on our behalf must be accountable to the people. So in the temporal world, they believe in secularism, that all power of the republic belong to the people. And these sinister and jihadists, what they're trying to do is to grab the country from the people, because all power of the republic belong to the people, and they want to say it belongs to the temporal realm, not just the spiritual realm. The temporal realm also belongs to Almighty, and somehow they're the representative of God on earth, and through this divine power and this divine law, only they know what they are. They have the right to govern. So parties like Jamaat Islam or even Hizbut, and I've seen a draft constitution in the social media circulated by Hizbut and Jamaat's own party constitution. It's abhorrent and repugnant to the Republican character of the constitution that we have. So they want to replace that. And it seems to me that throughout whatever political struggle we are having in Bangladesh, extra constitutional regime, there's one common denominator. And that is to change the secular character upon which Bangladesh is born, to make it non-secular, giving a state religion and take secularism out, which is what this committee has done. That is, it is so obvious. This is so common. And this is something, as I said, we are the first nation, first Muslim majority people who have gifted ourselves an autochthonous constitution based on secular democracy. And so it shall be. And so be it. And it shall be so forever and more. Nothing can take that away from the people of Bangladesh. Thank you.
Thank you, Tania Amir. And that wraps up our discussion for today. Today we have discussed a range of issues surrounding the Constitution Reform Committee's recent proposals. We have discussed legitimacy of the current interim government led by Dr. Muhammad Yunus. We have discussed his own terms of reference. We have discussed the terms of reference of the Constitution Reform Committee. We have discussed qualifications, authority, motives, and risks, among other things. So a massive thank you again to Barrister Tania Amir for joining us and sharing expertise on such a crucial topic. And to our viewers, thank you for tuning in and being part of this conversation. If today's episode got you thinking, we'd love to hear from you, of course. And please remember to follow the SADF YouTube channel for more discussions like this. That would also be a great help to us, really. Until next time, Stay informed, stay curious, and take care. Signing off for today, this is Rayhan Rashid. Goodbye, everyone.
Thank you, Rayhan, and thank you, your viewers. Thank you for having me.